My Lord, yes.
Thank you very much.
My Lord, can I just pick up a couple of things from before lunch? One is the question my Lord Justice Lindblom asked about paragraph 367 and the affordable housing statement. We're not confident we've tracked down the right document on that, so obviously it's one that Mr. Kalinsky's clients easily put their hands on, so if we can come back to you on that, I'll be grateful. Then the other matter is this, is to pick up the issues around the options on page 547 within the West Site obligations, part 1 of the schedule, and 1, 2 and 3, and in particular option 2 that the Lord Justice Lewis was asking me about before lunch. And this may to some extent bear on the point my Lord Justice Lindblom was putting to me before lunch about rationality, which is even if this were not pinned to provision of money, as we say, paragraph 364 requires that it be. The question is then the evaluation that sits behind that. So option 2 on page 547 involves the grant of a leasehold interest in the land, and just bearing in mind at this point this is not transferring a building with things built in it, it's transferring a piece of land. And then the developer to pay the council or registered provider the net SR construction costs in accordance with paragraph 3.7 below. And 3.7 is essentially a phasing mechanism, apportioning 10%, 40% and 50%. It doesn't actually tell you what the net SR construction cost is. In order to get net SR construction cost, you need to go to page 424. Which tells us that the net SR construction cost means the difference between the social rented construction cost, which is on page 433, that's the cost of constructing, including demolition, the 116 and any non-residential, so far so good. There's the difference between that and the total value of the social rented units and non-residential element within the same building of the social rented units, so far so good, to be agreed between the parties or determined by the specialist in accordance with paragraph 3.3 of part 1 of schedule 1, and so on. So the issue then is that what on the face of it looks to be a mechanism to identify the difference between the construction costs and the value of the land being transferred, which wouldn't meet what we say 364 requires, because we say 364 requires a sum of money. But even looking at it, as it were, on its own, on the alternative hypothesis, the difficulty with that is that the mechanism for determination of the value of the asset being transferred, it is conditioned by reference, as you see there, to paragraph 3.3 of part 1 of the schedule. Apologies if this is a bit of a cold towel exercise, it's not of our making. That is back to page 547. Which says this, social rented construction costs, the value of the social rented units and non-residential units, and the net SR construction costs shall be agreed between the relevant parties, so that's repetitious so far, all calculated by reference to a specialist in accordance with provisions in clause 20. Clause 20 defines the specialist, so we don't get any more from that. Provided that, and it's the proviso which is the sting, any value or agreed or directed, by a specialist shall be at least the value attributed to those parts of the viability appraisal. And then application viability appraisal is defined, if we go back to the beginning, as being appendix 10 to this document. So when in 10 years' time, if we're going down the option 2 route, we're working out the net SR construction cost, the value in that to be attributed to the asset being transferred has a floor, FLOOR, below which it can't go, namely the value placed on it as at this date, or for this process rather. Now, That's all very well if the value were to increase, but there can't be any certainty about that. So in the mechanism associated with option 2 is a protection which operates for the developer in that calculation. So one starts, and I don't want to labour the point, one starts with a proposition that this is going to give them land plus cash if there's a shortfall, but actually it doesn't, or certainly doesn't necessarily generate that. So to pick up, in a sense, both my Lord Justice Lewis and my Lord Justice Lindbom's proposition, if we're not about delivering up cash, we're simply about delivering up the units, to put it through the prism of rationality, as my Lord Justice Lindbom put it, this isn't a rational mechanism for doing that, because it's got its own floor, FLAW, in the floor within it. And that's the short point that I was probing for before lunch. So that's the point in relation to that part of the schedule. The next part of the schedule we need to go to is part 3. This is part 3 of schedule 3, which is dealing with the buy to sell fallback, which arises in the event that the developer elects to develop the west site in that way. And the trigger for this in the officer report, you'll recall, was paragraph 365, and its reference, we'll go back to the text, of course, its reference to the requirement to secure the 50%, which is the SP6 level of evaluation, as part of the review in the event that the developer has this further election on what they do. Now, what we then see, however, in part 3, under viability, is, you see it in the recitals, that's obviously not the critical place, but beyond that, it is the introduction of reference to policy P4, which, as the court will recall, this is the third paragraph on page 559, as the court will recall, policy P4 sets a different requirement, or would set a different requirement where it's enforced, or where it's operative. We, though, aren't concerned with the recitals, but that's just introduction to the point. The page 561, we start to see the trigger, and I'm jumping over because I don't think we need it, viability reviews 1 and 2. So these, as the court will recall, the basic viability reviews are dealing with a situation in which economics change in this long-term process. So 2.1 says, in the event that viability 2 results in the development meeting the affordable housing cap, viability 3 will not be required unless, you might get the affordable housing cap simply by virtue of an uplift in values, or economics, but you also inevitably also get there if the developer has served the relevant notice to operate this election. My Lord Justice Baker, who was, sorry, I anticipated a question there. No. So that's the trigger to get into this process. If you get into this process, we're over the page at section 4. 4.2, in the case of a viability review, the council shall assess, so that's the first point. Then 4.5, the council should complete its assessment and notify the developer. And then 4.6, if the council determines that additional affordable housing is required, the developer shall deliver it in accordance with the provisions of this schedule. So that's the delivery mechanism. Then paragraph 5, section 5, where it's determined pursuant to 4.5 that additional affordable housing is required pursuant to a viability review, the developer shall provide such additional affordable housing as soon as reasonably practicable and subject to 5.2, etc. So that's then the delivery mechanism for the additional affordable housing. That takes us back, it would take us back to the definition of additional affordable housing as it was in the Section 106 agreement originally. I showed you that on page 402, but that's what's overtaken by the deed of variation. The deed of variation you have in tab 3, and that gives us the new form, additional affordable housing, up to a maximum of the affordable housing cap as follows.
Sorry, which page are you on there?
685.
Thank you.
And we're here concerned with bullet 3, because bullets 1 and 2 deal with the position under the viability reviews if it's simply a change of economics. Bullet 3 deals with the buy-to-sell election, where the west side provides open market units for sale, up to a maximum of 15 additional social rent equivalent habitable rooms to be provided on the west side, with a commensurate decrease in the number of intermediate housing habitable rooms. So that's where we get, first of all, to pick up the point that Mr. Harris rightly picked me up on, this is social rent equivalent habitable rooms, so rather fewer units. But more particularly, two things relevant to our case. One is the cap of 15, and two, that these are social rent equivalent rather than social rent. Now, our argument, in a sense, responding to the way the council puts its position, is in layers. The first and simple proposition is that paragraph 365 of the officer report, as adopted by members, identified that in the event of the review mechanism, what one would be seeking to secure what was the 50% level, 50% being the policy compliant SP6 position, which the development had been falling short of. And within that, we say there is no scope for any cap of the kind that we've got here. But before I go any further, I mean, Lord, I'll come back to that. I'm in danger of going into my ground, but just to give you a trail of where we're going, it's looking at the intra-virus, or rather the virus, for capping at that level, and the SRE rather than SR. I'll come back to those things in a few minutes, if I may, when I do it specifically under the headings of the individual grounds. But that's the trail for those submissions, if I may. So, my lords, that then is my long and it's expanded in the light of questions, but as often is the case, helpful illumination of the background to the case. If I could then just pick up the grounds, which I think I can then deal with relatively quickly, because we've traversed a lot of this ground already.
All right. And now, just before you embark on the ground, you'll take them obviously as the sequence that is appropriate for your argument. Your opponents have grouped the grounds in slightly different ways. Do you wish to deal with them in a grouped way or individually?
Well, I am going to deal with them to some extent. Well, it grouped inevitably. Let me signpost what the grouping is.
Yeah.
And this is to take them slightly out of order they are in our skeleton, and in particular to take ground 6 earlier than it appears in our skeleton, which might be, I don't know why we put it there, but it's a confusing position to have it. So I'm going to deal first of all about the general approach to delegation, scope of delegation, I should say. Then I'm going to deal with 364.
Yeah.
That's our ground 2. Then I'm going to deal with 365. That's our ground 3. Then I'm going to deal with, as a component of that, SR versus SRE, which is our ground 6. Then I'm going to deal with the agreement in principle point, whether that's called an error of fact or misleading report. And then flowing from that, the section 31 point, which relates to that particular ground and the way the judge analysed it. So I think that's 4 and 5. That's 4 and 5, exactly.
Yeah. So just going back, sorry if I'm being slightly...
No, it's our fault.
No, not at all. You've identified grounds 3, 6, 4, 5. Your the first 2 bullets, or the first 2 headings you gave us just now, are grounds 1 and 2 taken together, are they?
Essentially. Well, ground 1, to some extent, informs 2, 3, and 6.
So effectively, just so that I know at the outset, you're effectively with 1 and 2, 3, 6, 4 and 5.
Yeah, exactly.
Okay.
Apologies for a slightly opaque sequencing before. So I think my lords have a lot of the vast majority of the sort of foothills of all of this analysis already. But round one concerns the judge's approach to understanding the scope of delegation. He set that out in paragraphs 48 and 49 of his judgment. This is where he explained, which I think remains the position, that there's agreement that one doesn't simply look at the resolution itself, one looks also to the officer report to understand the scope of delegation. And the issue then really is how one approaches that document. The judge approached it essentially by reference to principles that my Lord Justice Lindblom had set out in the Mansell judgment, which the judge quoted in his paragraph 46, his paragraph page 123 of the bundle. We say, as my Lord Justice Lindblom said in the opening passage, that those are the principles to be applied when criticism is made of an officer's report. And that's absolutely right. And at least for the purposes of these grounds, we're not making any criticism of the officer's report. And so we simply say that's the wrong kicking off point. So all of the injunctions within that analysis, we say are inapt for this exercise. We say, once one has accepted, as everybody does, that the officer report is part of the framing of the scope of delegation, it's not merely giving reasons or explanations or identifying considerations, it's also part of understanding the scope of delegation. We say, essentially, the principles to be applied are those which the Supreme Court has identified as being objection in a world where we are ever less concerned to distinguish different types of document. You have that in the legal materials bundles at tab 9. It's the Trump International Golf Club case. And we would simply draw the court. I don't know if you've
Do you want us to look at? Do you want us to look at?
It's really only two passages in this. They're very familiar. Page 131 of the bundle, 97.
Something dramatic happened, but what it was, I'm not sure.
No, voice is off.
It seems not to have had any lasting effect.
Let's hope whoever it happened to is okay.
Yes. Well, I'm sorry. I've not resisted the temptation to go to the authorities bundle, and since I'm there now, I wonder whether you could just take us to the passage of Trump.
Page 131 of the bundle.
Yeah.
It's paragraph 33 and 34 and 35, but 34 in particular of Lord Hodges' judgment, yeah. Where he distances himself from the approach of taking different approaches to construct different kinds of documents. And says, really, this is the guts of it. When the court's concerned with the interpretation of words and a condition in a public document, we're not here talking about a condition, we are talking about a public document, it asks itself what a reasonable reader will understand the words to mean when reading the condition in the context of other conditions and of the consent as a whole. This is an objective exercise in which the court will have regard to the natural ordinary meaning of the relevant words, the overall purpose of the consent, and the other conditions which cast light on the purpose of the relevant words and common sense. And then you get a similar Lord Carnworth, page 140, paragraph 66. He says a little bit, but I don't think he particularly adds. He's more talking about reference to extrinsic documents, which was an issue in that case. We say that's the approach here. What one has to do is recognise that the report is performing multiple functions here. It's partly information to members. It's partly then explaining the reasons that members did things, and as the resolution itself then identified, it identifies the considerations which have led them to this recommendation and this resolution. And we say those considerations include what they were specifically told, and we say acted on the basis of at 364, 365 and so on, which in the case of 364, just to pick up that as the first example, was a clear stipulation. And those paragraphs, whatever else they're doing, because they fall of the legally operative framework of delegation and understanding the virus for the chief planning officer, director of planning, have to be understood that way. And in a sense, either the courts on that approach, we say there's no in principle basis and no authority to support the approach taken by the judge or by the other parties, not least because, well, there's no authority, and the authority that they rely on, which is what Lord Justice Lindblom was dealing with a different question, which is what happens when somebody's criticising the reasoning and by extension criticising the report. And all of those injunctions in that analysis, which tend towards a generous approach to understanding those things, we say are inapt here, because this is legally operative in the way that a planning condition or a planning commission would be. It's deciding the scope for officers. It's something, its context is important, because this is not just about members clear what they have or haven't delegated to officers, the scope of the delegation. It's also about officers' understanding and indeed developers' understanding. And the point is plainly of much wider importance, because as I mentioned earlier on, this is a process which goes on up and down the land all the time.
Just also, Mr. Wood, you started with the extraction of the report on one of the grounds, whether or not the agreement in principle misled the councillors, is exactly what is dealt with in those grounds. But when you go to 48 and 49, and 49 in particular, is it really correct, when you're looking at these grounds, that the judge was transposing those principles rather than setting out what he says at 49 in particular?
Well, so I understand my last point. When we come to the points about affordable housing levels, that is absolutely forswear Mansell territory. So it's a different point. It may be that the judge in 49 is working from first principles.
Well, if you look at 48, I said about grounds 2 and 3 deal with the question of whether or not the 106 agreement was within the scope of the delegation. Then at 49 it says, in connection with these contentions, it was accepted. And it appears to be this paragraph that is looking at how you should approach in that context the scope or meaning of the delegation that you need to look at, really, isn't it?
My Lord, if my Lord is putting to me that this is not necessarily grounded in Mansell, then I won't push too hard against that. This may be the judge speaking, as it were, from first principles. But in which case, in my submission, he gets the principle wrong.
But that's the question. What is wrong with paragraph 49 rather than what is wrong with a different question, which was he right to apply Mansell to this if that's not actually what he's doing? It's really a question of what's right or wrong with paragraph 49, I think.
Well, in the end, that was always going to be the case, my Lord, but my Lord is helpful to distill it that way. It really starts, I think, 4 lines up from the bottom of the page, that this question needs to be approached in a manner consistent with the principles upon which officers' reports to committee is to be considered as a matter of law. Now, that may not be a reference back to Mansell, it doesn't matter. It's a fresh proposition. This question is to be considered firstly on the basis the officer's report is to be read without undue legalistic rigour. Just pausing for a second there. We say that's undoubtedly the case if you're looking at the officer's report for the purposes of understanding the reasoning and so on and deciding whether the officer's misled members and all those Mansell type things. But if one is concerned with understanding the scope of delegation, then that is a lawyer's question. It's a question for the court, because vires is a legal question. And then the judge says, colon, it is a document designed to guide and inform the decision under consideration. Absolutely correct. Not a statute, contract, or formal legal instrument. Well, It's not a statute, it's not a contract, but in this regard, it is a formal legal instrument because, as all the parties agree, it's informing at some level the understanding of the scope of delegation. So it is a formal legal instrument. Secondly, in that light, when approaching this question, it's necessary to consider.
I'm not clear, so sorry to be pedantic. You missed the middle sentence. In my judgment, the question of what was appropriate has to be understood by reference to the contents of the officer's report and the advice that the members had received and upon which they based their resolution. Then he says the officer's report is to be read without undue legalistic rigour. Are you saying it should be read with overdue, very legalistic, strict rigour, or not? I mean,
No. I'm not. Plainly, I'm not.
That's all right then, is it?
Well, it depends, like all these adjectives. It depends what he means by that, because in the end, and maybe the crux of this is in what follows beyond the colon, is that it is a formal legal instrument in this regard. It's setting the scope of the legal delegation, and so it has to be read with appropriate legal rigour. But the appropriate legal rigour is for a definition, which is for a passage in a document which is setting the scope of delegation. It's not a passage which is merely telling you the information that members had or explaining their reasoning. It's a passage which is telling you the basis upon which they made their context of 365. It is specifically, and that's why those paragraphs are particularly interesting, telling you about what the Section 106 agreement will do. So particularly in relation to 364, we have this language which tells us what the Section 106 agreement will do. And that, we say, it is absolutely formal legal and has to be approached as such. And the approach to that then is the approach set out, as I explained, in the Trump International case.
Do you say there's a verb missing where it says, he says, guide and inform the decision? Is there a verb missing, or is there's the right verbs to describe what the report is doing?
Well, a report undoubtedly does those things. It guides and informs members, but it can do, and in this instance and in these regards, did do more. In that not only did it tell them, well, one can envisage different situations. So one situation is where the officer's report says in trenchant terms, this is what the development will involve. And then there's another layer, and there may be more layers to it than this. There's another layer, which is the one we have, which is where the report goes beyond merely telling you what will happen, in the sense of the development will look like this or like that, and actually tells you that the Section 106 mechanism is going to be the mechanism to deliver that. And it uses the clear language in Section 364 that we have. So the judge isn't wrong when he says about the purpose of the report. It's incomplete. And that may not be an answer to my Lord or Justice Baker's question. But
well, then what about the last sentence in that paragraph? Do you accept that's an accurate summary?
Let me just check.
It's you.
Whether measured against this approach, well, that's the right word. Blurring into the next question. That's blurring into the next ground of challenge. Obviously, the question of whether they exceeded their discretion and their scope of their delegation is a question that the court needs to consider. But the first question is, what's the scope of their delegation? And that's why we say that the judge underestimates the role and significance and so on of these passages in this officer's report.
But I think that depends on giving a particular status to paragraph 364. If you look back to the middle of paragraph 49, the bit you didn't read out, in my judgment, the question of what was appropriate, because that's the delegation, the resolution which says an appropriate legal agreement, and what's appropriate has to be understood by reference to the contents of the officer's report and the advice that the members had received. The report wasn't drafted as the instrument of delegation. The report was drafted as the report to advise and inform and to guide members. Then there was the resolution. In order to work out what the resolution means, you have to have regard to what's in the report. So I don't know that it's necessarily correct to say that paragraph 364 was performing a different function from other paragraphs of the report, i.e. it was prescribing a legal formality or setting out the basic framework of a covenant to be included in the Section 106 agreement. It was part of a very lengthy report, the contents of which report had to be taken into account when you work out what's appropriate.
Well, it depends what one means in that case by the words take into account, I think. Because there are all of the report needs to be taken into account in deciding what was appropriate. But some elements of the report, and this paragraph is not only an important matter because it's the subject matter that concerns my client, it's also phrased in a particular way. And going back, if I may, to Lord Hodge in Trump International, it's what would the reasonable reader, what would the reasonable counsellor have understood was being achieved by this passage? What were they doing when they voted for this resolution on the basis of a passage that said the Section 106 agreement was stipulated? Would that be taken by the counsellor to be merely a sort of general blandishment to officers to deliver up social housing, or would it be taken at face value, read as ordinary language? And I do go back then to the point Lord took questions to me before lunch about the words, and we talked about the word covenant as a lawyer's word. The word stipulate is an interesting word because it's both legalistic but also colloquially understood. It's not a word that has a particular term of art, so it would be understood by the lawyer, but also understood by the counsellor in the same way. It's a very clear and very specific and very operative word. And really the question then is, interpreting that as the reasonable reader in the mind of the counsellor as to what this was achieving and why they were voting for this resolution, what were they delegating to officers, what were they expecting officers to be able to do? We say the answer is stipulate and then the words that follow.
Going back to my just to come back then to my question before we adjourn, the words that follow, i.e. follow the word stipulate in paragraph 364 of the report,
yes,
represent in substance, is this right? They represent in substance what the members were guided to expect. Is that right?
Well, the word guided I'm bulking on. Because
all right. Well,
stipulate is rather clearer than guide. That's
directed, if you will.
Yes.
Led to believe.
Yes. That's a fair enough way of putting it. They were led to believe that this is what the Section 106 agreement would do. They voted for the proposal, the recommendation on that basis, and we say that then step 3 defines the scope of delegation. But as I say, we haven't found any cases that deal with this point. But we have, and we sent it to you separately. I think turned up the Kiddies or Kiddies, I don't know how you pronounce it, case, which is you I hope have loose, which is I'm not suggesting for a second it's on point because it's dealing with the understanding and application of a local scheme of delegation which was set out in a delegation policy. So it's not dealing with how you understand an officer's report in this context. It's dealing with a policy, and it's also dealing with a policy where the scope of delegation was explicitly informed by, or implicitly informed, said the court, but by a planning evaluation, because the delegation was to delegate things that were consistent with development plan policy rather than those that were not. So that required an evaluation by the officer in question.
Sorry, I was trying to get Mr. Wolf's attention. Just to be clear for the Lord Justice, I think Mr. Wolf is referring to.
Oh, sorry, Carlton
Conway.
I'm very grateful. I'm very grateful.
It may be that the Lordship's followed that, but I want to make sure that everyone's on the same page.
I'm very grateful. That's a complete
certainly.
I'm very grateful for Ms.
We have been sent Carlton Conway, but we also had Kidesh. So Ms. Sackman's intervention is helpful.
It's extremely helpful to me.
So the submission you've just made attaches to Carlton Conway, not to Kidesh.
Exactly right, my lord. I'm very grateful to Ms. Sackman. Yes, I'm talking about Carlton Conway. She's absolutely right. Carlton Conway, which is dealing with the delegation under a local authority scheme, and what it's paragraph 21 I need to look at if you've got the copy to hand.
Yes, certainly.
Paragraph 21. So paragraph 1.9 is the paragraph.
You'll have to give me a moment because it was sent separately electronically, and I now have to locate it. I'm sorry about that, but it's not in the authorities bundle, is it?
No, it's not. I'm afraid.
No, just give me a moment.
Of course. My Lord Lewis, you're muted. I don't know if you intended us to hear what you...
Maybe better if you did it. I was just saying it's very slow at the moment, and if it's not in the bundle, it becomes more complicated then to track it down. But I've got it now, so just wait a moment. It's not me, it's the computer system. Right, okay.
My Lord, it's really paragraph 21. Page 6 of the printout, I suspect. Paragraph 1.9, which is the paragraph within the scheme of delegation, is, in my judgment, to be construed against background that's plainly the policy of the relevant statutory material and circulars that will be public participation in planning decisions. That's the context for understanding the approach, including participation by those who are affected by them. That's part of recognising the importance of the role of councillors in making these decisions and the public participation element of that, which in Carlton Conway was, as it were, binary because the members weren't involved at all, the office had done the decision making. Here it's a bit more subtle. Anyway, the next sentence is the one that we just draw the court's attention to. Where powers are delegated to a single individual, the scope of those powers must be carefully considered. And then it goes on to talk about things which are specific to the provision in question. So it's the general proposition. I appreciate it's the sanctions in danger of taking out of context, but we say it's apposite here as well. And this, as far as we found it, there's a linked case called Springall, which is in the bundle, which I don't think, doesn't add to this thinking. So just to pick up the point in Springall that I think it's Mr. Harris's submissions referred to. It's in tab 6 of the bundle. This was a case like Carlton Conway. It refers back to Carlton Conway. Indeed, Mr. Kalinsky was involved in it, relating to a scheme of delegation and a policy of delegation. Mr. Harris refers to paragraph 34, which I think is on page 60 of your bundle. So this is in the context of a situation where the officer, in a sense, he decided his own scope of delegation because it depended on the policies. And the passage I think Mr. Harris refers to is 34. While I'm conscious of the important interest of public participation in planning decisions, to which Lord Justice Pill rightly referred, paragraph 21 of his judgment, there's also a strong public interest in the efficient, timely administration of planning control. Parliament has left it to local planning authorities how they may discharge their decision-making in planning matters. Given their extensive delegation of such role, it would be contrary to both public and private interests and cause much delay and expense to subject the system to what could routinely develop into a two-stage challenge of officer decision. So that's speaking in the context of a situation where I think it says somewhere else in this report 90% of decisions are delegated to officers. So that's about the split of the delegation between whether things come to the committee or are simply dealt with by officers. We say it's not on point here, where what we're talking about is the scope of delegation where members have already been involved, and we say have stipulated what needs to be done. So I simply show you those because we think those are the only bits of authority which really shed any light at all on this question. And that's ground one about judge's approach. Ground 2 deals with paragraph 364, and really I think we've probably gone over most of the ground, if not all of the ground already. It's the judgment at paragraphs 59 through 62. And really, 62, 63 are the crux of it. In 62, the judge refers to the point that was before him from the defendant interested party, about line 6 down, which is the practical difficulty point. So something which apparently hadn't been thought of in the process of framing the officer's report emerged in the discussions later and created what's called a practical difficulty about the delivery mechanism. The judge treats that, and indeed the defendant interested party treated that, as a basis to go beyond, outside what paragraph 364 said. We say that's the wrong approach, because if this practical difficulty hadn't been envisaged, then whether that was a question of it being out of scope in a virus sense because it went beyond the officer's delegation, or whether it was in the Kiddush, if that's the correct pronunciation, sense, and I think I'm right on to use it, refer to that case this time, a new development, a new material consideration, either way round, either it's outside our scope, the officer should have said, or this is a change of circumstance, the officer should have said. Either or both of those reasons should have led the matter to go back to the committee if they wanted to proceed with this problem. But in one sense, we don't get. But
in fairness to the judge below, 62 is recording the submissions. It's really 63, and it's quite clear. And he may be right or he may be wrong, but in fairness, it's quite clear from 63 that what he's doing is deciding whether or not the paragraph you have regard to the underlying purpose of securing delivery, or whether it was dictating how it should be done. And it is in that context, about 6 lines down, it says that it's notable that there's a practical difficulty. And he's not saying he's departing from it because there's a practical difficulty. That's not the suggestion. What he's saying is that's one of the pieces of the jigsaw that persuades him that the purpose of the paragraph was to set out what was intended to be achieved rather than to be a mechanism of stipulating how it should be achieved. And he's either right or he's wrong. But that's not doing what you're suggesting.
It may be that I'm over-reading the relationship between 62 and 63, and I'm very happy to be over-reading that relationship. But however one puts that, the practical issue element, we say, is not a proper part of the understanding of the scope of 364, or a basis to step outside the scope of it. However one puts that.
No, but is it part of the context of deciding the question of what is the scope?
Well, in my submission on basic principles, not, because if this only emerges after 364 has been drafted and voted upon, it can't change its meaning. 364 meant what it meant on the day it was voted upon in the members in July of 2018. If something emerges after that can't be part of the context of understanding the scope of 364. But I may have misunderstood my Lord's question and proposition.
So if we look at the sentence in the middle of paragraph 63, which begins with the words, in my view, which I think is, as my Lord says, what he's effectively deciding rather than submissions. In my view, it's clear that paragraph 364 was directed to ensure that if those obligations related to non-delivery of affordable housing were triggered, then the defendant will be provided with the wherewithal, both in terms of land and money or value, to ensure that social rental units were nonetheless delivered. Are you quibbling with the words or value?
I am. I do. I am.
So if those words were excised, that would be correct, would it?
Let me try to make sure I understand the question. The judge.
If you take the words or value, would you don't agree with the
So
proposition?
then the judge would be correctly reflecting what paragraph 364 in terms of outcome was seeking to do, and he's and insofar as he's reflecting the mechanism, the sufficiency of money, he's simplified it, and I'm loath to sort of construe the judge's sentence.
Are you
Sorry.
I'm so sorry, but I think this is germane to what you've just been saying. Are you submitting that the addition of the words "all value" in the sentence to which my lord draws our attention is an unwarranted and actually unlawful gloss on the words of paragraph 364 of the report?
Yes.
Is that the essential submission?
Well, that's one place at which the point crystallises, absolutely.
Yeah. I'm so sorry, I cut in, and
No, it's helpful.
I only wanted to clarify that. So please complete your answer, my lord. I just want to be clear.
I think we've got there. I mean, that is a good point to crystallise where the judge goes wrong, because that is not what section 3, so paragraph 364 says the section 106 agreement will stipulate. It goes outside that scope.
What he says in the concluding sentence is that his interpretation deals with, in a realistic and practical way, with what you described with the practical difficulty that was identified later on, doesn't he?
Well, the difficulty with that is that if I understood the point correctly, that is at risk of the practical difficulty being relied on as changing the scope of the delegation, of rewriting 364. And the practical difficulty can't be part of the understanding of 364 because we're told it didn't emerge in people's thinking until afterwards.
Well, 364 doesn't address the practical difficulty.
No, exactly right.
364 doesn't address how it's going, in any detail, how it's going to be done, does it?
Well, it addresses...
provides guidance as to the direction of travel, doesn't it?
Well, no, I'm afraid I wouldn't accept that. The word stipulate is not a word of guidance and direction of travel. It's but what follows the stipulation is, we say, crystal clear. It's not a guidance proposition. And the court's either with us or against us on that. We say that those words are important. And I think I'm not going to repeat. If you could just sort of read back in what I said immediately after lunch about the mechanism and the option 2 analysis, even if we were in the territory of a reasonable approach to delivery, what we've ended up with here is a mechanism that isn't going to achieve. You can't achieve that, or potentially can't achieve that, because of the approach to valuation.
Require would be a good synonym for stipulate, wouldn't it?
Yes, I'm always sort of slightly.
Stipulate doesn't not really a legal word, is it? It's not. There's no. I don't think it's. I can't think of an instance of it being used in any statute, for example. The Lords probably meant better than I know. But it's directive rather. You say it's directive. It's a directive word. It requires.
Absolutely.
Yeah.
Take a different example, remote from this, but just to test what 364 was doing. Would it or would it not be lawful to provide a sum of money which would cover all the construction costs to a basic standard, but not a good standard, but a basic standard, in 3 instalments? 1/3 day the building begins, 1/3 halfway through, 1/3 on completion. Would that be lawful?
Well, potentially yes, because that imports an evaluation by the officers about the sufficiency question, and the word sufficient does import an evaluation by the officers, and I mean, in the same way that Carlton, Conway, and Springhall involved evaluations by officers. We might look to see whether there'd been that evaluation and to see whether it's not part of our case, but whether that 10/40, whatever it was, phasing arrangement achieved that. That's not part of our case, but that would at least be part of the evaluation by officers of the sufficiency of the land and the sufficiency of the money. But what is clear and not part of any evaluation in that equivalent way, we say, is that it has to be land and a sum of money. And
no, I understand that. I'm just testing it. So there's not a requirement, as suggested in your skeleton, that it had to be the delivery of the total amount of the anticipated construction costs before the start of the project. So it's not directing at that level. It's simply saying the project has got to be funded out of money provided by the developer.
Yes, and that's the essence of sum of money, because that means the council can do it without involving any other aspect of its finances. In a context where local authority finances are complicated, that members would be aware that there's a difference between achieving a piece of land that you may or may not be able to use or realise value on, and cash that allows you to deploy builders.
No, that's my whole point. You might not get 2/3 until well into the development. That's why I said, would it be lawful or would it not be lawful to have 1/3 of the anticipated construction costs paid on the day the building work starts, 1/3 on a date halfway through the anticipated length of the project, and 1/3 on the conclusion of the project, which may be 2 or 3 years hence.
I may be completely misunderstanding my lord's point, but this situation, and I'm not sure how far you're going away from the situation we're dealing with, because in the situation we're dealing with.
Well, I said I'm going away from it in order to test it.
Right, but then the question would be, if we had similar language to this, or same language, it would be a sufficiency evaluation for officers.
What I'm trying to test is this. You're saying this directs a particular way of achieving the delivery of the social rented housing. And I'm testing different aspects to see how far this paragraph was really meant as a direction than a guide. That's what I'm trying to do, and I've got no views on it either way. And I'm wondering, what if the problem was different? Not the option 2 and 3 problem, but a different problem. The council would get 1/3 on the day that they took over the building work and started, 1/3 halfway through, which may be 2 months in, and 1/3 at the end of the project. Does this give discretion at the very least as to the phasing of the amounts?
Well, it's a sum of money sufficient for construction. So
Yes, and it is that. The point that I'm asking, you assume for the moment that sum of money is sufficient. They agree on day one is £10, but they get it in 3 instalments over a 2-year period.
But if 2 years, I think I'm being very dim here, but if it takes the council 2 years to build the 116 social rented units on that plot, and they potentially have an agreement with their contractor that they can pay them in instalments, then that's potentially sufficient, because they're not needing, because it means they're not needing to go beyond the cash that the developer's providing them. But if the timing, as I've picked it up from my lord's question, was such that wouldn't be sufficient, they wouldn't be able to pay their contractor, or the job would be quicker and the money would only come later, then that wouldn't be sufficient. So that would be an evaluation. But the essence in both cases is that
the money costs £1 million. The councils have spent that by the end of the first year, but they don't get the rest of it back until actual completion, when they've done the landscaping and so on, and that's 2 years later.
But then it wouldn't have been a sufficient sum to do the construction. That's the essence of the.
So you say that it actually has got to be up front. Sufficient for construction and completion means that they've got to get the money before they actually incur any costs that the money are meant to fund.
Well, that isn't part of. I mean, I'm dealing with my lord's hypothetical. That's not our case. We haven't complained, to go back to option 2, which had some phasing in it. It's not part of our case that the 10.
No, but don't worry about the point. I thought it was clear. I put it 3
No, I'm
times.
sorry,
But
What this has illustrated is that
don't
some
take
money
that
is
to what is not so important.
sum of money is pretty vague, isn't it? It's not qualified except by the phrase sufficient, etc.
Well,
That's what example illustrates.
Well, that's right. So there is an evaluation around sufficiency, and we accept that. But it's still a sum of money. And can I just also?
Well, can I just ask you this, Mr. Wolf? If option 2 had said the developer to pay to the council or registered provider a sum of money equivalent to the net SR construction costs, would that be sufficient?
There's the problem with net SR construction costs that we've identified. I mean, we're not complaining. Sorry, I may be misunderstanding the point here. We're not complaining about option 2, paying money in instalments. What we're complaining about is option 2 is not the provision of a sum of money, or insofar as it's a sum of money, it's only the top-up element, and that top-up element is itself calculated on a floored base, floored as in FLAWE and FLOORE, floored basis. Can I just return, if I may, to my Lord Justice Baker's question about the word stipulate? One advantage of a remote hearing where everybody's on the computer.
Yes, Miss Sack was able to give me some.
She's given me the instant OED.
Yes, I thought.
Which I'm just reading my email. It says demand or specify brackets a requirement close brackets comma typically as part of an agreement.
Yes.
So that very much
the same place as I was.
Okay, well that maybe that puts it very squarely into sort of legalistic. And it actually it locates it in something which is part of an agreement. So it's an entirely appropriate word to use in the context of stipulating the 106 agreement.
Can I just go back to the point I was making a moment ago?
Sure.
So, if option 2 had the phrase a sum of money equivalent to the net SR construction cost, then that would be a sum of money, wouldn't it? And and the question then would be whether the council had sufficient funds to construct and complete the units, wouldn't it?
Well, I think let me just try and understand my Lord's version. Sum of money equivalent to the net SR construction costs. If by equivalent one is saying equal to.
Okay, equal to.
Equal. Sum of money equal to the net SR construction costs, then that would be what we are asking for if the definition of net SR construction costs, so if it weren't net SR construction costs. The problem with net SR construction costs is twofold. First of all, it's only the top up of cash more than value. So it involves the payment of cash, but it's only the excess, if you like, of the construction costs over the value of the land that you're getting. And as I explained just after lunch, the valuation of the land is conditioned on an entirely inappropriate basis because it's fixed, or it's got a floor, which is its value as at 2019.
So your complaint then, maybe I'm Jim and I missed it. Your complaint is not that this was this failed. It failed to comply with 364 because it wasn't there wasn't a sum of money. It's that the sum of money wasn't sufficient.
No, it's absolutely no. Sorry, my Lord, I think I've misled you. It's absolutely that it wasn't a sum of money. But my point about 364, about option 2 and the net SR construction costs was partly a response to my Lord Justice Lewis asking me about those options, and partly a response to my Lord Justice Lindblom saying, what about this as a discretionary exercise? Is this outside the bounds of sort of a rational approach? And those questions would arise if this isn't a virus question. Yeah, on the virus question, if we're right on the virus question, then option 2 is out the window because it's not a sum of money sufficient. It's a sum of money which is only sufficient if you top it up with land values. And on the Lord Justice Lindblom point, if this is a discretionary exercise, then it's irrational because it's a mechanism built upon a valuation for the net SR bit, the netting bit, which fixes or floors the value of the land being transferred at 2019 prices.
Can we just pause there? Can we take each of those Can we take each of those in turn? You said there are 2 elements. I'm going to ask you questions about each in turn. The first element was that it was the net element. It was the costs above the value of the land. Yeah. But leaving aside sufficient for a moment, many people might say there's nothing to be said to be wrong about saying if the council gets the benefit of the value of the land, but it costs more to put the houses on there, what they ought to get is the difference between the value of the land and what they've got. And sufficient, wouldn't that be capable of accommodating that particular amount? It's sufficient for construction because they've got the value of the land, and they're getting the money for the difference. The value of the land is £1 million, but in order to put the houses on there, they've got to spend 1.2 million. So what they get is the 200,000. Isn't that sufficient for construction and completion?
No, because it's not a sufficient sum of money for construction. It's topping up it's relying on the council being able to realise in some way the value of, in your Lord's example, £1 million, in order to fund to pay its constructing contractors. There's not a sufficient sum of money for construction. If you step away from our case and say this can be done partly by transferring land, which is not what 364 says, then obviously it's entirely appropriate for the council to build in a top-up mechanism, cash top-up, if the value of the land isn't enough to pay for building. That would be part of the delivery on the judge's analysis. It's ultra vires on our case, but it's part of the delivery on the judge's analysis. But it itself, to go back to my Lord Roger Lindrom's proposition, would then be irrational. This is not our primary case. This is, in a sense, dealing with the case one step back, because it involves a method of calculation which assumes that the land values don't fall from 2019. Which,
well, that's my next question. You've said about the floor, but this comes into effect in 10 years' time, if it isn't built within 10 years' time. So they put the floor of today's value for 2019 value for what will happen in 2029.
exactly.
Right.
But you can't have an optional.
Acceptable, is it to say, and that's not acceptable to say, well, we're working out what's sufficient. We've got to tie somebody down for what's going to happen in 10 years, and we'll take as the floor today's value in working out what's sufficient. That's not a working out of sufficient.
No, it's not. It would be fine if it's the qualification, which I don't know how it's appeared in the negotiations. We've got the trail of the Section 106 agreement negotiation. It's the element in it's the proviso in I've now lost it. The proviso in page 547, paragraph 3.3. The last 2 and a bit lines,
Yeah.
which shackles the valuation.
Or I'm putting it to you, because they're trying to work out what something might be in 10 years' time, they valued it to the best as they can. They don't think it's going to go down that much in 10 years' time. It's likely to go up in 10 years' time. So in working out what's going to happen if in 10 years they haven't built it, they're simply saying, we've got to work out what's sufficient. We're doing that now in the best predictor, that it would be worth less than that, maybe worth more than that. And I'm saying, why isn't that a calculation of what's sufficient? Because they've got to agree it now.
Well, it's not put as a predictor, my lord. That section 3.3 starts off as a calculation based upon at the time, which, as my lord says, is 10 years hence. At the time, what are the construction costs? What is the value of the land? Those are values which could be coded into the Section 106 agreement without any idea of what they were going to be, and then applied perfectly properly in 10 years' time to the then construction cost and the then value, which is what you would need to know at that point if you were simply looking for a delivery mechanism. The difficulty.
Can I just pause all this for a second? I don't want to interrupt it completely, but the question of what is sufficient is a matter of judgment, isn't it?
Yes.
Is that right?
Yes.
It's not a matter of cold objective fact. It's a matter of judgment.
Yes.
Therefore, if that be right, then when the officers receive delegation to go away and negotiate, in the light of paragraph 364 of the report, at some point in that negotiation, they have to exercise judgment as to what is sufficient. Correct?
But well, more likely, which is sort of what they've done, put in place a mechanism for determining that at the time.
Well, we haven't got to that yet. Let's take it in shorter steps. They have to judge what is sufficient, and the developer puts forward a formulation of option 2, and to that formulation a judgment has to be applied. Is this sufficient achieve that which is indicated as a stipulation in paragraph 364. That's a matter of, dare I say it, planning judgment.
Well, I agree with that, but let me just explain the base of my agreement. The first step is that the sufficiency is a sum of money. That's what 364 says. It's not a sufficiency of combination of money and property. So that's the binary virus question. But even if we're wrong on that, and it could somehow be a sufficient sum of money and land, which is to go back to the all value point that we saw in paragraph 63, that is a matter of planning judgment, but it's not our primary case. It's the second layer. It's a matter of planning judgment. And we say this is not a rational valuation because of the proviso. Anybody who wants to bet on property values going up from 2019, sitting here today.
So it is an irrationality challenge after all.
No, well, that's why I'm trying to be very careful about it. It's an irrationality challenge if we're wrong on the. I'm really not. Sorry, Millard, I'm obviously not explaining myself.
No, well, I think you are explaining yourself. It's what I think. What I think you've succeeded in submitting very clearly is that whether it be right or wrong, I'm not expressing a view about that. But you've made it very clear that this is, as it were, you haven't used this expression, but I think this is really the substance of it. This is at a prior stage to any consideration of irrationality, because this is a question of construction in the first place.
Yes.
A construction of, you've described it as a instrument of a legal instrument, I think, paragraph 364, given the status infused into it by the resolution. And that one looks at that as a matter of construction in the first place. And you say, doing that, option 2 cannot, as a matter of construction, as a matter of law, be brought within the compass of paragraph 364, and that's the end of the matter. Yeah. And that doesn't engage any questions of a rational or irrational exercise of planning judgment, because we don't even get there. And you've made that submission very clear. And
as long as you've got that, as long as everything that's
well, I think that is extremely clear. I was perhaps going to the secondary stage, which is the question of what actually happens when the officers have to negotiate this thing. And they, at that point, subject to the argument you've just identified, subject to that, they have to exercise a planning judgment, and that they have to do it within the bounds of rationality.
Yes, assuming the judge's formulation is quite helpful in that regard, because he says land, money, or value. If that's permissible, then it's a sufficiency evaluation around land value or land, money, or value.
You say that, but you say that, and it goes back to the original question, my Lord Justice Baker, that the addition of the words "all value" is fatal in that.
Out with the delegation. It's out with the delegation.
That's the argument. Actually, that is, if I may say so, the beginning and end of the argument.
Absolutely. And we only get into discussion about option 2 because I'm sort of dragged there by evaluation of why option 2, about the mechanics of option 2, and questions about rationality. And we say, even if we're wrong, even if the judge is right on land, money, or value, then that's not our primary case, and I know you have that. Then option 2 fails because of the mechanism it includes, which is not an attempt to ascertain. If you start just by looking at net SR construction costs and read those words as if they were ordinary words, you might feel optimistic about it. You might feel this was going in that direction. But when you go through the cold towel exercise of working out what the components mean, and you get in that exercise the paragraph 3.3 and the proviso, and I think I'm right in saying, but I will dig this out next time. I think this emerged in the course of the hearing before. I think I'm right in saying those words were added in at some point to the drafting. They weren't in earlier versions, they were added in.
Mr. Wolf, am I right? And may be barking up the wrong tree here, but you don't look at option 2 in isolation, do you? Because it sits alongside option 3. Because the way, am I wrong? I mean, tell me if I'm wrong, I could easily be wrong, but as I read this, choice of whether to, the way in which the options will be selected are that first of all, the developer decides whether to exercise option 1.
Yeah.
And if the developer decides not to exercise option 1 and gives notice,
Yeah.
then the council has the choice of option 2 and option 3. Yeah.
That is right as a matter of contract, because it's stated in clause paragraph 3.5 of part 3.
Yes.
Does it the fact that the council has got option 3 as a alternative, is that relevant to the interpretation of whether option 2 complies with 364?
I'll let Mr. Harris develop that if he wants to.
But Mr. Harris is liable to present an argument against you.
He's not. Yes.
And I'm very happy to pick up the cudgels, but
what my lord is asking, Mr. Wolf, is given that the council has the determination as to whether it's option 2 or 3, we've got to look at 2 and 3 together, because that's the council's initiative. See whether those 2 options read together, or disjunctively, I suppose, can be fitted within 364.
Well, I started down the trail. I apologise if it's a bit of trail. Because of questions to me about the operation of 364. So that's what I've happily addressed.
Well, I mean, what did you?
If this bit.
Just option. Don't you have to take into account option 3 when considering the extent to which option 2, the assertion option 2 is beyond the scope of 364?
Well, the difficulty with option 3, if we want to get into the detail of it, is that option 3, the closing line and a half of option 3 says this: the cost of constructing the social rented units being reflected by the value of the non-residential floor space transferred at nil value. But the potential difficulty with that is that these 116 properties are within a combined building. Yeah. And so what you need to do if you're relying on transferring land land is not just to transfer the cost of constructing the non-residential floor space, but also potentially the cost of constructing the other parts of the building, which have to be constructed at the same time, because you can't do the one without the other because of the way that the building is designed. And that's so if we were to go back through the grinding process of the definition of net construction cost, that recognises that you need to do the composite in that process.
But option 3, strictly speaking, does option 3 comply with 364? I mean, there is a sum of money. There is the land. There is a sum of money. And for clarification, you have the last 3 lines.
Well, it isn't a sum of money sufficient to build.
Well, it is, because for the reasons explained in the last 3 lines.
No, sorry, I may misunderstood, but the last 3 lines explain that the idea is you're not transferring a sum of money, you're transferring a piece of property, the value of which is intended to reflect the cost, which is not a sum of money. So we go back to where we started, which is the sum of money point.
Well, is it?
That sum of money sufficient?
Yeah, I mean it's
cumulative.
I don't know whether this is the right concept, but money or money's worth.
Well, that's
value. Or value.
That's not what 364 says. That's the difficulty. That's what.
But it falls, as my lord points out, the last 2.5 lines of option 3. The cost of constructing the social rented units being reflected by the value of the non-residential floor space transferred at nil value. In other words, we're giving you at nil value, nil cost. It means, I suspect, the non-residential floor space, and that represents the monetary worth of the social rented unit.
I'm going to give you a plan.
The difficulty with that is that what that is seeking to, assuming you can have value as opposed to sum of money, so stepping away from our primary argument, sum of money, why is option 3 similarly flawed in a way that option 2 is differently flawed, right? Because what option 3 is seeking to explain is that the cost of constructing the social rental units is reflected in the value of the non-residential floor space. The difficulty is you can't just construct the non-residential unit, sorry, the residential units. You have to construct the whole building. And you see that if you go back to 424, which is net SR construction costs, which links you to option 2, where we were a moment ago. What we have to do is we have to look at the whole building, because you can't isolate the residential elements from the non-residential. That's, I forget which floor they're on, but they're on part of that building.
Just looking at 364 again, Mr. Wolf, and if we're treating this as a kind of formal legal instrument, the last 3.5 lines are the land and sum of money, pause for breath, sufficient for construction. What my Lord Justice Baker said. It's the combination, it's the land and sum of money that has to be sufficient for construction. And if the council decides that the value of a particular area of non-residential floor space, together with the £1, is sufficient, why doesn't that fall within the literal wording?
But because we say that's the wrong way to read 364.
Because you've got to, the sum of money and construction have got to be related to each other. The land is simply the thing that is going to be built on, and the construction is the sum of money. So the land enables you to complete because you've got the land, and the sum of money is related to the construction cost. That's it, is it?
The sum of money is related to the construction cost. Yes, I may be misunderstanding the point.
Any of my questions are difficult. I'm sorry, I'm tougher than Mr. Wells, but it's quite an easy question, that one, just like the others were. It's the land and sum of money sufficient for construction and completion. And as I understand it, you're saying the sum of money has to be sufficient for the construction costs.
Yes.
So the land, therefore, you're getting the land for what? To enable you to complete.
Because because the point of this is delivering the units. You can't deliver, the council can't deliver that without the land. So
right.
it needs to be given a long lease on the land and put in a position through 364 a sum of money where it can do the building.
This doesn't sound very viable for the developer. If the developer's going to give not only the land and including the non-residential floor space, but also a sum of money to pay for the building, and it doesn't sound viable.
No, but let's not forget that the developers, what everybody wants is option 1, and indeed, well, better than option 1, which is that this just happens. This is all dealing with the fallback situation, which the developer, for some reason, whether the scheme's, the developer's gone bust or walks away, or the scheme's gone badly wrong or whatever, this is the protection, the mechanism of protection. So, Lord Justice Baker, can I come back to option 3?
Yes.
I need to distinguish, if you're looking at option 3 as an escape route, between option 2. Option 2 talks about transfer of the net SR construction costs. Yeah?
Yeah.
Could you just hold net SR construction costs? Okay? So we follow net SR construction costs back to the definitions at the beginning.
424, is it?
424.
No.
And net SR construction cost says the difference between the social rented construction cost and the value blah, blah, blah. So social rented construction cost is a term of art in the agreement. If we go to the definition of social rented construction cost, it's on 433. It means the cost of constructing, including demolition, the rented units and any non-residential units forming part of the same block. So option 2, the netting off exercise, involves calculation of the cost of building both the residential and the non-residential elements, both of which you need to do because of the building configuration. We go back to option 3. Option 3 in the closing words, which we were looking at a moment ago, doesn't pick up those terms of art. It simply refers, in ordinary language, to the cost of constructing the social rented units, which doesn't import the cost of both the residential and the non-residential, which you have no choice but to build because it's in the same building. A lot of this Section 106 agreement requires a fairly cold towel and a trawl through the definitions.
So what's the consequence of that then?
Well, the consequence of that is that option 3 isn't pardon the expression, the silver bullet that you might have thought it otherwise would be.
Well, what circumstances will the council choose option 2, and in what circumstances will it choose option 3?
Well, it depends on the relative construction and land value costs of the time.
At what time?
10 years hence, which is the point at which this all crystallises.
Right.
And the difficulty is that option 3 doesn't include the top up, and so the land value may not be enough to do all the construction you need to do. So if the land value hasn't risen or has indeed possibly fallen in a new London world, you get to 10 years hence, and the value of the land in your hand, you the council, is not enough to construct the residential and non-residential alongside the pound that you're given in your pocket. So that's not an answer. So you then say, is option 2 my answer? Because there's a top-up payment, but the problem is that the calculation of the top-up payment includes this floored floor. So in this world where land values have dropped, or not risen sufficiently, depending on how it works out, or construction costs have risen considerably and land values haven't kept pace, or whatever it may be, lots of combinations, neither option 2 or 3, because of flaws not in any valuation, but simply in the mechanics of them, offers the 364 route out.
But in terms of what it's aimed at doing, this is intended to lead to an agreement in about 2019 to cover events that may or may not occur in 2029. So there's got to be some element of assessment, hence the use of the word sufficiency, in 2019. You can't work backwards and say there's the possibility that in 2029 land prices may have fallen, construction costs may have tripled or something. The thing is, they're in 2019 trying to reach an agreement which will cater for an eventuality 10 years hence, and they've done that in option 3 by saying you'll get the land on which the social rented units are going to be built, you'll get £1, and you'll get the equivalent value of the non-residential floor space, and judging it as best as we can in 2019 when we have to enter into this contract, we think that will be land and money sufficient to construct and complete the units.
Just refreshing that this is all not my primary position, because this is land and value territory. There's no difficulty, to go back to my Lord's opening proposition, with putting in place a formula which generates sufficient funds. Indeed, on this land and value proposition, it might be thought that option 2, were it not for the proviso, the flaw in evaluation, would be capable of doing that because it does secure the cash top-up.
So you seem to be saying the only kind of agreement that could have been entered into in 2019 is one that would commit the developer in 10 years' time to providing a cash sum sufficient to meet the building costs in 2019 of the socially rented units. That's what the officers had in mind when they wrote 364.
I think you may have said in about 2019, 2029, but yes, that's exactly right. That's exactly right. That's what they specified because and come back to my Lord Justice Baker's provocation to me. This may look tough for the developer, but let's not forget the context for all of this. The developer is coming along, and nobody doubts their intentions, with the intention of doing a 10-year scheme, and in the back end of the 10-year scheme, they will deliver up the social rented houses. And members have agreed that phasing is acceptable. But members are concerned because of that phasing that there's a risk that the development, the lucrative bits of the development will occur early on, and for some reason the remainder won't be completed. And simply having a Section 106 agreement obligation to require the developer to do it may not be good enough in the financial circumstances of the time. So members have said that the Section 106 shall stipulate a mechanism that everybody hopes won't be necessary. Everybody hopes it won't be necessary, but it will, in that sort of ultimate fallback situation, generate for the council the thing which members were seeing as being the important prize here, which was 116 SR units. So it's a fallback that nobody's hoping for, but the important thing is members saw it as fundamental, and that's why they resolved in the way that they did in the context of this report.
But the intention was that the council could only enter into this agreement if it had a clause in 2019 committing the developers in 2029 to paying whatever the sum of money was to fund the building costs for 119 units in 2019 or 116 units.
If the developer hadn't done it, I mean that doesn't look attractive from the developer's point of view. Obviously not, because the developer has the much more attractive option of option 1, which is as part of building the W3 and so on buildings, it can at relatively low incremental cost at that point include the SR houses, and everybody hopes and expects that to be what will happen. The difficulty is if we get through all the east side, we get through half the west side, and that building in the west side is unbuilt, it's got to be built somehow to get the SR housing. So it's not an attractive option in a sense for anybody. It's not what anybody wants, but that's why it's the critical protection that secures the highly policy important SR housing component in the event that something goes wrong with this development. Well, I'm sure Mr. Harris's clients aren't setting out to do that, but the council is right to protect itself from that eventuality.
Right. Well, I suspect that we've probably explored these points.
I think we have.
And unless either of my lords has a further question to follow up.
Thank you very much. Thank you, Mr. Ball.
Thank you.
No,
We'll
I'm grateful. I'm grateful. And apologies, I am now behind, but I'll do what I can. With it, so that picks up ground 2 in the 364 point. We're then dealing with the different position, which is that the developer elects to develop the west site as build to sell rather than build to rent, and it's called the fallback position in the officer's report. And it's paragraph 365 and to some extent 404 sheds light on it as well. And the context for this, as you recall, is that this scheme is not compliant with policy SP6 in particular, which specifies the 50% requirement for SR housing within the affordable housing 38%. And so the references we have to 50% being the requirement following the review are necessarily references to the SP6 requirement. And what is being said is this is part of the opportunity, the situation in which we, the council, through the viability related reviews, can improve improve the SR component at a later date. So this is again down the track in the future as things evolve, and that 50% then is set as the benchmark for what is being required of the mechanism to do that. And the difficulty, it's really probably in the end we can encapsulate it in the agreement, the variation of the original deed. It's page 685 in the deed of variation for section 106 agreement. You need a little bit more in terms of steps on the way to get to contextualise this, but I think I took you through those sufficiently before lunch. And the simple position is in bullet 3 in the replacement text on 685, where the west site provides open market units for sale, open market for sale units, up to a maximum of 15 additional social rent equivalent habitable rooms to be provided on the west site, and a commensurate decrease in the number of intermediate housing habitable rooms. So that's a shift in the balance. We'll have 15 additional social rent equivalent habitable rooms, or up to, on this assessment. And the difficulty, the illegality, again, there are layers to this. First layer, the illegality is in the capping of that level, because, again, the virus of the delegation was to secure a mechanism that sought, obviously subject to calculation at the time, up to 50%. And there's nothing in that that allows you to cap the number at 15. That's the first layer of it. My Lord, if it assists, my Lords, our arguments on this before the judge were set out in our skeleton argument and supplementary skeleton argument. So our supplementary skeleton argument, this is in tab B2. So these are the stages of the argument. Step 1, the cap of 15 is simply ultra vires. Then it's page 176 in the core bundle, which in turn refers one back to our earlier skeleton at page 143. Because what emerges, what has been done, and this is Mr. Kalinski, I know, will develop this in his submissions, and I'll let him explain it to the court, is that this figure of 15 has been evaluated not by using the 50% threshold applying SP6, the aspiration as 365 requires, but by saying, let's do a completely fresh planning evaluation based upon a different policy combination. And what Mr. Kalinski will explain to you is the way in which the 15 has been derived by applying P4 as well as SP6. In other words, not applying the 50% that comes from SP6, which is what the paragraph 365 required, but applying P4 to the east site and SP6 to the west side. Now, there is nothing in 365 which permits or contemplates introduction of policy P4 into that evaluation. But even if there were, the approach that's adopted by the developer and the council, we say, is an entirely flawed one. It's perhaps best illustrated for brevity on page 166 of your bundle, court bundle 1, I'm sorry, which is in our skeleton argument, where we put at the foot of the page, let me just talk you through the table at the foot of the page. just recalling that we say policy P4 just doesn't enter the calculation here, but even if P4 enters the calculation, this table illustrates the way the numbers would have to work. So what this table does is it splits the construction down into east site and west site, and it identifies the number of habitable rooms generated on each site, 1604 and 1754 respectively. And it says, okay, if contrary to what 365 says, we are going to apply P4 to the east site because that's build to rent, the 12% figure you get from P4 would give you 192 habitable room equivalents. The other part of the site is undoubtedly SP6. There can't be any equivalent about that, even on a new policy application. So what we have there is 1754 rooms, and we have 50% of 35%, which gives you 307 rooms. So even if you could somehow introduce policy P4 into the approach and somehow treat the two bits of the site as separate, that would give you 192 plus 307 equals 499. The one, and then that takes us to the right-hand column. The 499, which is the aspiration at that point, is then compared to the 450, which is what the 116 units translates to, and gives you a deficiency, and we've done the maths there, of 49. So even if you could somehow legitimately introduce P4 into the evaluation, the deficit, the shortfall to be delivered on top of what's already in the bag, would be at most capped at 49. So if you were to look for a capping figure based upon including a policy which is not contemplated by the members' delegation, the capping figure would be 49 habitable rooms equivalent, not the 15. Now, the only way that the council and the developer can get to 15 is by a process which literally involves taking away the number you first thought of, and it involves somehow treating the 192, which comes in this calculation in relation to east sites, as if they were part of the ultimate development, and then recalculating the SP6 component on the west site. And my lords, frankly, we are not clear how that is said to be justified, because this is a single project, a single proposal. You don't treat it as one development on the east side and then a subsequent separate different development on the west side. It's part of a single proposal. But as I say, that is the third level of the argument. Level 1, it should be 50%, there's no capping. Level 2, P4 has no part in this. Level 3, even if P4 has a part, and you're looking for a number, it should be 49, not 15. And in a sense, that's the exercise, but actually the simplest point, and the point at which we say that the judge went wrong, is to step away from what members required, which was that the policy shift needs to be a shift to 50% requirement, as referred to in paragraph 365, that is the SP6 requirement. So that is round 3. Taking the grounds out of turn, ground 6 is still within that review mechanism. On page 685, as I was looking at it, the variation of the deed, these additional units, whatever their number, are to be provided as social rent equivalent habitable rooms and not social rent rooms. And it may well be that part of the quirk in the debate we were having much earlier in the day is that one might think that when one uses the expression social rent equivalent, that means it will be social rent equivalent. But actually what's emerged here is something which is not social rent equivalent. It's defined as that, but it's not equivalent in the sense that anybody would understand it. It is different. And we can argue about the materiality or the scope of the differences, or the range of them, but some of them are fundamental. And I'm not going to go over the exchange we had much earlier in the day, but they include the ownership, the tenure, and the rent review mechanisms as being differences from what is a well understood, well established and well valued social rent. Traditional social rent is the wording used repeatedly in the contemporaneous materials, as opposed to this other ethereal beast. Now, by contract, the Section 106 agreement, the developer has contracted into some of the peripheral elements of that, but it remains materially different. And we say it's not for the court to get involved in the evaluation of that, precisely because the members saw that as material, and indeed the developer did too. And I showed you, and I won't crawl back through it, the ways in which, from January to July, the improved affordable housing offer was in part to do with numbers, but in part to do with type. And there was a considerable welcoming of the change of type. And that's why we say, when one looks at paragraph 365, and one is looking to uplift in the event of the buy-to-sell fallback, looking to uplift from the 116 to some other number, you're uplifting within the same type. There's nothing in 365 that would allow or countenance the uplift which 365 contemplates, requires, to be done by a different kind of housing. And indeed 365 itself refers to the requirement would be 50% social rented, 50% intermediate. So that again is part of the framework of delegation to officers out of which they stepped. As I say, even if we were wrong on the pure delegation point and therefore the capping figure, the approach which the council describes, and Mr. Kalinsky will no doubt elaborate on, is simply impossible in relation to 364 because it involves P4 and it involves a calculation which erroneously treats the development as two separate sites rather than one, which is what it actually is. Well, that is ground 6. Ground 4, again, we canvassed this considerably earlier in the day. This is about whether members were either misled in a Mansell sense or proceeded on the basis of an error of fact in the E sense. And I won't take time going back over the case law on those two, but they're different ways in which before the judge we put the point and before this court again we put the point. The position here, as you'll recall, is that the officer's report at 371 talked in terms of the grant having been confirmed. That was qualified by the addendum at page 246, the supplementary bundle, 11, paragraph 11 and paragraph 23,
Sorry.
where it was qualified to say,
Mr. Wolf.
sorry,
Which page are you on?
I'm looking at 246 and 248 in the supplementary bundle.
246, 248.
It's both in the addendum.
Yeah.
In both of those, the language shifts from the language of 3671, so it is indeed softened to say agreement in principle. Now, the point that Lord Justice Lewis put to me, of course, agreement in principle is not the same as guaranteed, which is why people were seeking confirmation that the provision would be guaranteed in any event. It wasn't dependent on the grant coming forward. So there was a recognition of the contingency, the risk, But even at the level of in principle, we say that misled members and or was an error of fact by reference to the true position, which this wasn't agreed in principle. All that had happened was that the developer had been told they were eligible to apply, which is very different to agreement in principle. And that's the trigger for one or other of those legal routes through to identify the legal flaw. Now that then takes us into ground 5, which in terms of the judgment is at paragraph 56. Or 55 and 56, I should say, where the judge says, well, even if that were right, even if there were misleading or an error of fact, he would have applied, so this is obviously not part of the ratio of his decision, because he doesn't get to this point, but it's a fallback position from the judge. He would have applied section 31(2)(a) to say that it's highly likely that the outcome would have been the same. And that's where the exchanges that I had this morning with Lord Justice Lewis were so helpful, because as often is the case, Lord Justice Lewis alighted very quickly on the thinking, which is very simple, which is that if members had appreciated that the developer was prepared to commit unequivocally to the 116 with only a possibility of an application for money, that was very different potentially from a developer committing to the 116 with an in-principle agreement. Those are fundamentally different propositions. I'll give you 116 because I've got an in-principle agreement. I'll give you 116 and I'll make an application. They are fundamentally different propositions. And going back to I'm not very good at the gambling metaphors, but going back to the card game metaphors, members would then have been in a position to say, or to consider saying, on a properly informed basis, no, we want more. And as I indicated, taking you through the reports, and I don't propose necessarily to take you through them again, the policy context for all of this is a negotiation. That's the language used of the Mayor's policy. Para 3.12 of the London Plan is a negotiation. And we've seen, as a matter of history, what happened here when the council played hardball, if that's an appropriate expression, between January and July. The offer went up in terms of numbers and the improved type. And that is not answered by the fact that, as at the 3rd of July, the council officers were saying this is the reasonable maximum, because they said exactly the same thing in January when the offer was considerably lower. And we also know the potential materiality of the council grant, because we're specifically told in documents that I've shown you that it was that potential 11 million that allowed the developer to contemplate the rise from 73 to 116. So all the elements are there for members, had they been properly informed, to say, well, if you're prepared to commit to this unequivocally, even on a wing and a prayer, then we think you should put forward a higher number than the 116. And the judge's response to that, we say, is where he steps into the impermissible territory. And this is paragraph 56, quite a long paragraph. It runs over the page 57. The end of 56, it was submitted therefore by the interested party that had the defendant sought a higher contribution in relation to social rented units, the interested party would have refused to agree to it, providing it, leading either way to a refusal of planning permission and a subsequent appeal or an appeal non-determination. Speculation as to what might or would have happened, which we say, it won't take time drawing the court back to it, but my Lord Justice Lindblom in the Plan B case, in that panel of the Court of Appeal, very clear to be, we've got that at tab 12 of the legal materials, the role of the court in process.
Mr. Wolf, just pause. Just pause for a second. I don't know whether I'm the only one whose reception at the moment is not good.
So I'm not sharing intermittent words either.
Oh, I'm sorry. It must be at my end. In that
I
case.
don't know. It may sometimes it helps if we switch off microphones if it gets like this.
Let me turn off my camera and see if that helps you.
Or if others,
Can you hear me more clearly now? I think
perhaps I could prepare others to turn off their cameras. It might help. So, Mr. Wolf, if you'd like to turn your camera back on.
let me give it a go.
That's better now.
Is that better now?
Yes, we can see you now. So,
Can you hear me?
I think we've probably got a bit more capacity.
Okay. I'll give it a go.
So just, sorry, what you just introduced Plan B in the Court of Appeal, and the passage that I'm pretty sure I know you're going to take us to. Did you want us to look at that?
I'm very happy to do so. It's paragraph 273 on just after page 290 in the bundle. The passage in the Court of Appeal's judgment starts at paragraph 267, but the operative paragraph is paragraph 273.
273, yes.
It's really line 5, line 4 or 5. In particular, the court shall still be cautious about straying, even subconsciously, into the forbidden territory of assessing the merits of public decision and challenged by way of judicial review. And what we've got here is a version of that, which is the judge either speculating or agreeing to a speculation as to what might have happened. And we say that's simply an inappropriate exercise in this context. Because we say, once the legal error is made out and we say it is, we've identified, obviously it's for the defendant to show, the party to show it's highly likely the result would have been the same. We've identified why it might well not have been because of the history and the way this evolved in the policy context. Quite wrongly stated the judge then to accede to a submission which says it would all have worked out the same anyway because redeveloper would have said no or gone to appeal. And that's not an appropriate evaluation. So the judge is wrong in principle to go down that road. And that's why we say that wasn't the basis of his decision because he didn't get to section 31. It was a contingent evaluation of section 31. So we say that was wrong in principle.
You submit that were we to get to that point, the approach indicated in paragraph 273 of Plan B Earth in the Court of Appeal is an appropriate caution.
Exactly right. Exactly right. Exactly right. So my lords, I'm not seeing any urgent emails metaphorically from behind me. The only other point that is raised in the skeletons against us is in relation to relief, where the suggestion is made that in certain circumstances, depending on the findings of the court, it may not be necessary or appropriate for the court to push the planning commission. It could simply adjourn matters to allow the council and the developer to renegotiate elements of the Section 106 agreement. And indeed, there was a floating in the skeleton argument of the interested party that they might renegotiate bits of the Section 106 agreement even before we got to court. Obviously,
that hasn't happened as far as
that hasn't happened. As far as we know, it hasn't happened, and as far as the court knows, it hasn't happened. Obviously, the relief that would follow would crucially depend upon what the court decided and why. So I wasn't proposing to be drawn into those matters.
No, I think that's right, if I may say so. I don't think that at this stage, at least, we need to hear you on those matters. I just look to my colleagues to see if they agree with that.
I agree.
We're all agreed on that, so we won't trouble you on that for the moment, at least, Mr. Wood.
My lord,
subject to emails from your junior on any points.
Which I haven't had, so as long as my email's working.
Do you want to pause? Do you want to pause just for a second?
I don't think anything's coming. I vigorously, I think she'd literally shout out, as she did helpfully before if there was an issue.
I assume Sapman, though she's not on the screen at the moment, that she's following
she
this.
Would jump up if she needed to, I know. So, Lord, unless I can assist further, those are our submissions.
Thank you very much indeed, Mr. Wolf. Thank you. Now, Mr. Kalinsky. You're on the screen.
I'm on the screen and audible. Thank you. Things, Your Lordship, I propose, unless there's a more convenient course, to deal with this through responding to the grounds, following the order that Mr. Wolf has just developed. So grounds 1 and 2 together, 3 and 6, 4 and 5. I will need to develop some factual points, but I obviously won't overlap on points that have already been covered, and I'll do it in the context of the response to the grounds, if that's a convenient course to take.
Yes.
So the starting point in relation to the delegation grounds 1 and 2, if I could just try to encapsulate what the defendant's position is, and then chart a course for dealing with that in a little bit more detail. So the defendant's essential submission is that the judge's approach to what was an appropriate legal agreement, authorised by the committee's resolution to grant planning permission, was legally sound. The judge did, and rightly did, take account of the context that Block W3, in which the social rented units are located, contained commercial units as well as social rented accommodation. And that being the case, the judge was correct, I say, to consider paragraph 364 of the officer's report in a purposive and practical way, I submit consistent with established authority for how to read such reports, rather than on the counterfactual basis that paragraph 364 prescribed precisely how the specific clauses of the Section 106 agreement needed to be drafted. So that's the essence of the response. I propose to deal with it as efficiently as it's possible to do so in 4 stages. So firstly, just very briefly, submissions on what the terms of the delegation is, because there is an issue there. There's a lot of common ground, but there is an issue, certainly in terms of the way the written arguments are put, in terms of the instrument of delegation and how you then import the Trump-style approach to that on an analogy with the planning permission. So I want to make my position clear in relation to that. I then want to deal with some relevant factual matters as to the provisions of the agreement mostly, but also just showing 1 or 2 points of how officers thought they were dealing with it in their actual negotiations, in terms of linking it back to paragraph 364 of the officer's report. And then briefly, because I realise the court has this well in mind, just look quickly at what the judge's approach is and then respond to the criticisms in terms of the general approach and the factual conclusions. So that's the route map, but obviously I'll deal with it at the speed it's most helpful to the court. So the first step is just what the simple points of what's the terms of the delegation. Now, I want to make it clear what the common ground is. I certainly accept, as I did below, and as the judge approached it, that the term appropriate legal agreement must be informed by an understanding of what paragraph 364 expects. But I submit the judge was right to approach it on the basis that paragraph 364 was guiding and informing members rather than prescribing the precise drafting of the agreement. And by guiding and informing, the focus of that guiding and informing has to be the identified planning purpose. And the identified planning purpose here is securing the delivery of the units. It's not, and I'll develop this, but it's not securing the delivery of the units with absolutely no risk or outlay on the part of the council. That's not the planning purpose. And actually my submission would be that that would be out with the legitimate planning purposes when we have to look at what regulation 122 of the SIL regulations requires in terms of proportionality. So the focus, as the judge below appreciated, was on securing delivery. Now, the key references, obviously the court has in mind what the resolution says, so I can turn it up, but I'm not going to show the court anything it hasn't already seen. So, but I'll just do it briefly. So it's page 262 within the supplementary bundle. So that's at the back of tab 2 of the supplementary bundle.
Yes.
Page 262, and it's worth noticing, again, appreciate 2/3 of this has been said already, so I'll do it very briefly, but probably one needs to notice 3 elements of the resolution in the light of my Lord Justice Lindblom's observations in relation to paragraph 3. So first and perhaps most importantly is paragraph 1, the concept of the delegation being for the entering into of an appropriate legal agreement. Begs the question, what's appropriate? Common ground appropriate must take account of what's in the officer's report, but it's not, the instrument of delegation is not explicitly linked to any particular paragraph of the officer's report, although I do accept, putting the point fairly, that 364 is obviously a paragraph directly on point. There's a couple of others that are of relevance to understanding what an appropriate agreement is, but certainly 364 is one of those. Paragraph 3, I accept the point that my Lord Justice Lindblom made, that this is a case where there is express linkage. That's implicit anyway, absent an indication to the contrary. I don't rely on any indication to the contrary. So paragraph 3, in a sense, adds that element of one reads it together with the report, but it's really confirmatory of something that isn't in dispute in any event. And then I do say one should notice paragraph 5 over the page that your court's aware of, but wasn't specifically shown, which is the consultation requirement. So the essence of consultation, obviously, is that there is an engagement when the proposals are at a formative stage. So the essence of that negotiation, of that consultation, is capable of influencing the content. So that's an indicator, I would suggest, against the idea that there is a strict and literal anchoring to the precise wording of 364, the consultation requirement. So I don't put the point any higher than that. In terms of the key parts of the officer's report with which we're concerned in relation to grounds 1 and 2, I just would like to show the court, obviously 364 is worth just pausing upon because it's central to the grounds. And so 364 is at page 127 within tab 2 of the supplementary bundle. The opening sentence just introduces the context of the affordable housing isn't evenly distributed. The section 106 would therefore stipulate that if the agreement on the west side has not substantially commenced within 10 years of the east side commencing, the land and sum of money sufficient for construction and completion of the social rented units would be transferred to the council to deliver the social rented units. I would respectfully suggest the purpose is unequivocally there, the delivery of the social rented units. The question of what land and a sum of money sufficient for construction and completion of the social rented units begs a judgment as to what sufficiency means. And it's clear that that paragraph in itself doesn't wrestle with the practicalities of what this means in terms of the particular block W3, which has the commercial units sitting alongside the social rented units. So either that's an unhelpful straitjacket, and you have to go back to members, which is the way Mr. Wolf puts his case in part at the Kylie's stage, or perhaps more realistically, I would respectfully say, the question of what's sufficient takes account of all of the context, including the fact that there is other development parcelled up with the social rented units, and how one approaches sufficiency given that context is a matter of judgment, which is not inconsistent with the resolution read together with that paragraph of the officer's report. So that's the sort of the essence of the points in relation to 364. It's worth noticing that the other paragraphs that deal with the heads of terms in the report are very general in terms of what they include. So there is a section, if we go just to page 192 and paragraph 750, there's a section of the report that's headed planning obligations, and 750 notes that the Section 106 agreement is currently being drafted. So if we're reading the report as a whole, that's an indicator on the face of the report that the drafting might not have crystallised in relation to any provision, let alone the provision specific in paragraph 464. And then you have laid out the broad heads of terms in relation to the east site, non-financial obligations, and then the heading at the foot of 193 is West Site financial obligations, and then there's West Site non-financial obligations at 756, and it just says in broad terms to secure the affordable housing units, including review mechanisms and restricting a proportion of private units until and unless the affordable units have been completed. So in terms of the general guidance here, members would understand that there's a broad series of headings as to what the Section 106 is intended to cover, but the detail is very much a work in progress. And that's a relevant part of the context in which we should be construing. I respectfully submit the resolution read together with the officer's report as a whole.
The reference in 756 is where exactly? Sorry.
Oh, I'm sorry. It's terms to, so it's about a third of the way down, so probably halfway.
Yes, I've now got it. Yeah.
And then, I mean, and the other point to make is that there's a long stop, which I appreciate is a kind of standard term, but the long stop is a period of from early July to mid-December for the 106, and that's indicative of the fact that one might expect members to take account of the fact for a development of this scale and size, the negotiation of the Section 106 agreement may well be a substantial exercise that will take a degree of time and a degree of care and a number of iterations, and that's all part and parcel of the context in which I submit one should construe the resolution read together with the officer's report, and the learned judge clearly had that in mind. He does refer specifically to those provisions in his analysis, along with Section 364.
Paragraph 7 is quite interesting. I haven't focused on the wording before. In the event that the satisfactory legal agreement has not been entered into by a particular date, then again the reason for refusing planning permission would be failures to ensure adequate provision of affordable housing. I don't know whether that helps or doesn't help your case, but I haven't noticed before.
Yes, I think I respect you says it's slightly broader than that because it's also and mitigate against the adverse impacts of the development through the contributions. So I respectfully suggest it's neutral. I mean, I plainly accept and in fact positively submit affordable housing is an essential material consideration as part of an overall planning balance, and it's clearly necessary for there to be provisions to secure it. And my case is that has played out, and that. But what one can say is that we do have evidence of Mr. Bevan in his delegated report applying his mind to whether that deadline should be treated as an absolute cut-off, and positively deciding that it shouldn't, and issuing the planning permission on the understanding that there is in his evaluation an appropriate section 106. So, but I don't take that. I don't want to take that point further than it goes.
No, just I thought you were going to say it doesn't say fails to ensure adequate funding for the provision of affordable housing.
Well,
so one could say that this is enough anyway, so it may just be neutral.
Well, I'll leave it for my purposes as neutral, because it's really just there's an expectation. It must be common ground. There's an expectation that there needs to be an appropriate Section 106 agreement. Without an appropriate Section 106 agreement, the development would be unacceptable. But that begs the question: what's an appropriate one? And that's the key issue with which we're concerned.
Are you coming back to 364?
I can do so now if that's.
Well, I don't know if you are. You are presumably going to confront the basic submission made by Mr. Wolfe that one has to take what is effectively a strict construction of 364 and pay attention in particular to the verb stipulate. And we do need, I think, for our purposes, to confront that submission.
Yes, can I take that on board, but come to it at step 4 of my structure?
Yes, fine.
But I will certainly do so.
Right.
So I think I can move to step 2, which is just the factual context. So
can you take step 2? Can you take step 2 as your final page this afternoon, and then we'll finish.
Yes, absolutely. And it's 4:30 cut off, my lord. Is that right?
It is, yes.
Yes. So the first thing I wanted to check is the court. I'm not sure whether the court necessarily has in mind or needs to have in mind the precise plan of block W3, but there is it as part of the Section 106 agreement. Although I'm not certain how easy it will be for the court to read it, but at 624 there is a plan showing the actual composition of it, and you may be able to make out of that. That's within the core bundle. At 624 there's plan. I don't know how easy it is for the court to make out adjoining Pastor Street that there is marked on this plan 3 units of office/retail space. So the long block, the W3 block is fronts Oswin Street and Pastor Street, and adjoining Pastor Street there are 3 office/retails. That's the non-commercial units, and they are present at ground floor and also at upper ground floor, which is 624 is ground floor, 623 is upper ground floor.
It is rather small. I don't know whether there's a larger version of this. It's not terribly easy to read.
I wanted to give you the reference. I'm sure that between the parties you could be given that in A3 of.
Well, either that, or you can just take the section of this that is the one we're really looking at, and just send it in an email.
Yeah. Can I take that on board for overnight? Is that?
Of course, yes.
I just wanted to offer that piece of information as to where to find that, and also
That's fine.
It may help that there's a reference at paragraph 36 of the officer's report that describes the block as having 2,860 square metres of flexible retail and office space.
Yeah.
Now, obviously, it's common ground that paragraph 364 of the officer's report is silent as to that practical complication. but the council did put some evidence in, and I want to tread a line of not going against the indication that my Lord Justice Lewis gave to Mr. Wolfe, that he won't be assisted for the purpose of understanding 364 and looking at what people said about it. I try to keep that in mind. If your analysis of that's different from mine, you'll no doubt indicate that. I'm trying to keep that in mind. Can I just take a couple of references in the council's evidence? So, the evidence that the council put in was actually because this was a rolled up hearing. This was at the acknowledgement of service stage, and there's a short witness statement from Mr. Gorst, which is attached to it's tab B10, page 318. And I wanted to just show the court paragraph 11 of that, which was at 319. There's a heading at the bottom there, the approach to the delivery of social rented units. And this is just the account of what happened that may be relevant to keep in mind. There was negotiation between the parties as to how to give effect to paragraph 364. At the time of drafting the officer's report, the planning committee had not consulted with the regeneration department regarding the practical realities of securing the principles of paragraph 364. In the event of the social rented units not being delivered according to the agreed timescales, it would be the regeneration department which would have to step in to deliver the social rented units, as this would not be a planning function. Giving effect to the principle behind 364, it became apparent that the drafting would need to set out in some detail what the commercial terms of such a transaction would be. There were various iterations of draft and negotiations that took place on email and in meetings as to how to give effect to the mechanism referred to in paragraph 364 of the officer's report of facilitating delivery by the council of the social rented units if the developer did not do so. And then paragraph 12, which I won't, well, it might just be quick to read it, but in particular, it became apparent there would be practical difficulties of the council or a registered provider taking on the delivery of social rented units situated in a block which had a commercial element. The council would have to acquire the land which the social rented units were situated, would then have to deliver the commercial units as well, and then transfer these back to the interested party. Practicalities involved in that resulted in the council deciding it might be prudent for the council to have an additional option of retaining the commercial units as well, in order to ensure that the council received the best option. The agreement was drafted so the council had discretion to elect whether to proceed with option 2 and option 3. Now, I'll show you how that transpires in terms of the options, but the important point is the council was focusing on how to give effect to paragraph 364 in the mind of the officers. It hit a roadblock in terms of it wasn't as simple because you had to try and unravel this, and they had it in mind that if they're going to step in to start building, you're going to need to do that together with the commercial elements. And if you then do that, you've not got any entitlement on the face of it to those commercial elements. So then there would then be a subsequent transaction to pass back the commercial elements when completed back to the developer. So it appeared to be quite a convoluted analysis. Now that's part of the context for understanding how that problem was solved in terms of options 2 and option 3. And what they represent and how they, in the council's mind, were related back to paragraph 364 of the officer's reports. So I'll go to that now, because that's obviously quite important, but I just wanted to anchor it in the evidence. Okay. Can I go, there's the bit that I have noted but I'm going to miss is Mr. Wolf relied on the emails of Miss Hussein referring to 364, and I readily accept that doesn't help the court in terms of what 364 means. But I think what it does, I do submit what it does show is that it's of a piece with the council focusing on trying to give effect to 364 in the dealings which it had. If I then go to the heart of the matter, which is the terms of the section 106 itself, and 548 of the core bundle, which is within tab C2. The scheme of this, which the court obviously understands from the exchanges with Mr. Wolf, is that the developer has the unilateral right to go down option 1, but if option 1 is declined, then the council has the choice between options 2 and options 3. If one thinks about option 1, just for a moment, by way of context, which is the developer building out, the developer, if the developer builds out, then the developer's got all of the value attributed to the commercial units. It's obviously paid the construction costs, and it ends up with the value of the social rented units, and it would expect there to be some kind of transaction for value with either the council or the registered social landlord to put those units into beneficial use. So that's the kind of economic context of option 1. Now, I would respectfully suggest it's easiest to understand these two options by starting with option 3 and then going to option 2. So if one goes to option 3, this is the option that cuts through the practical problems that Mr. Gorst speaks to in his paragraph 11 and 12, because effectively it transfers the whole of the land to the council, and there's a notional sum of £1 as the sufficient sum for the construction costs. Why is that a sufficient sum? Well, the terms of section 106 itself say in terms the cost of constructing the social rented units being reflected by the value of the non-residential floor space transferred at nil value. That's what the tailpiece of option 3, paragraph 3.5.3 says. Now, those words were deliberately inserted into the section 106 agreement to relate that provision expressly back to paragraph 364 of the officer's report. And you'll see that at page 337A of the core bundle, which is within tab B10.
Sorry, 3.
It is, sorry, let me just find my reference again. 337A, my lord. So just to read this in context, this is an exchange between the council's lawyer and the interested party's lawyer, and it culminates in an encapsulation of the options, which is at page 337. But the particular bit I wanted to put in mind is the first sentence of the email of 12:20 p.m. at 337A. So this is Miss Hussein to Nicole Kingsley. And I have instructions from the client in respect of the points raised yesterday, points about the viability. I've therefore updated the 106 and resending it, having picked up the points below. I've also updated the West Site option 2 section. Now that option 2 is I think becomes option 3. I've now updated West Side option 2 section as the council was concerned that a fallback with no dowry payment might be perceived as a conflict with paragraph 364 of the Planning Committee report. I have therefore inserted a dowry payment of £1 and added some wording to explain why this value has been given. So the express evidence as to the drafting of the agreement is that the sufficiency of the £1 sum is expressly linked to the value of the non-commercial elements of the block that are practically inseparable from it. And my submission is, and I'll develop it, but that's not out with 364 on a pure vires point, because it can't be right to exclude an account for value. And my Lord Justice Lindblom is quite right that if you get into sufficiency, it becomes a question of rationality. And the evidence suggests that the council's regeneration department thought about this carefully, has got experience at delivering this, and formed the view that that was the simplest way of addressing this, given the complexity of the entanglement of the commercial unit. And it's clearly evident on the face of the agreement in terms of the way option 3 is drafted, and you've got the contemporaneous evidence showing that that is clearly intended, as it reads, to be an express reference back to paragraph 364 of the officer's report. So that's option 3. I'm inclined, given the time, to pause there, and I'll deal with option 2 in the morning, if that's convenient.
That is convenient. Thank you very much. We'll call it a day there. We'll resume again at 10:30 in the morning. For the hearing will be as today. We've not had reported to us any difficulties with either the live streaming or subject to the occasions where we've had to pause briefly from the legal representatives and others present in the virtual courtroom. So we take it that things have worked reasonably well today. If there are any difficulties or have been any difficulties that haven't been reported, please do bring them to our attention. We'll do what we can to sort them out. Otherwise, 10:30 in the morning. Thank you very much.